Episode 14, Jarvis vs. Swan Tours, Landmark Cases. The For Legal English podcast is now in session. On today's docket, we discuss the landmark case of Jarvis vs. Swan Tours Ltd. This 1972 English case concerns contracts and how to calculate damages. Lord Denning, one of the leading British jurists of the 20th century, wrote this opinion. Welcome to the For Legal English podcast. This is the show for lawyers, law students, and other professionals from all over the world who want to improve both their legal English and legal knowledge. In this podcast, we discuss different legal topics such as law in the news, law in practice, legal writing, legal movies, and other areas. I'm your host, Timothy Barrett. I'm a former practicing attorney in the United States, then turned law professor in Tbilisi, Georgia. Please check out our website. That's 4 is in the number 4, Legal English, no spaces or dashes.com, 4legalenglish.com. You can check out our blog articles, available courses, and the show notes for this episode. On the docket today, episode 14, Jarvis vs. Swan Tours, Landmark Cases. Jarvis vs. Swan Tours is a 1972 case from the UK Court of Appeals. The leading opinion was written by the Master of the Rolls, Lord Denning. Lord Denning is one of the most respected British jurists from the 20th century. Lots of important decisions written by him. It's an interesting one that sets new precedent. In the case, Jarvis was the plaintiff as well as the appellant. He purchased a Christmas and New Year's holiday in Switzerland after reading a brochure. And of course, after reading the brochure, it made it sound like it's going to be a wonderful trip, all-inclusive, everything included in the trip. He was expecting a nice party atmosphere with plenty of other single people. Unfortunately, he ended up spending his holidays mostly alone. What was promised in the brochure and what he faced in reality were quite different. Let me quote Lord Denning from his opinion. Quote, "The matter was summed up by the learned judge. Quote, during the first week, he got a holiday in Switzerland, which was to some extent inferior. And as to the second week, he got a holiday which was very largely inferior to what he was led to expect." Close quote. So first, what is a learned judge? This is a term that often we use in the courtroom to refer to another lawyer or a judge. If we're a lawyer talking about another lawyer, we might talk about our learned colleague. Or a judge talking about another judge might talk about the learned judge. Here, the appellate court judge is talking about the trial court judge, the court of first instance. So it seems pretty clear from the case that what was promised and what was received are pretty far apart. Misrepresentations or warranties. The judge goes on to say, quote, "I think that the statements in the brochure were representations or warranties. The breaches of them give Mr. Jarvis a right to damages. It is not necessary to decide whether they were representations or warranties, because since the Misrepresentation Act 1967, there's remedy and damages for misrepresentation as well as for breach of warranty." Close quote. Here are some more legal terms to discuss: representations or warranties or misrepresentations. So under common law, a warranty or a representation or misrepresentation were two different things. And one of the things that is important about that distinction is the remedies available were different. To put it simply, a misrepresentation was a statement that turns out to be false, but that induced or convinced the person to sign the contract, to agree to the contract because of that misrepresentation. A warranty is very similar, but it is distinct. A warranty is a term or a promise in the contract. We have to be careful too, because a lot of times we confuse warranty with guarantee. And all of these terms are very similar, but they do have legal distinctions. So a guarantee is not the same thing as a warranty, and a warranty isn't exactly the same thing as a representation. Traditionally, under common law, One of the big distinctions between the warranty and the representation is the representation or misrepresentation has a remedy of rescinding the contract, of basically canceling the contract, voiding the contract. Whereas if it's a warranty that's breached, then they can sue for the voiding the contract, to terminate the contract, to rescind the contract, to act like the contract was never formed, but they could also get damages. Think about the instant case. Does Mr. Jarvis want to rescind the contract? Well, no. He probably wants damages. He's already had the vacation. He spent the time. He's been to Switzerland. He did get a place to stay. He got food. So he did have some part of the contract was lived up to. Does he want to cancel the contract? That's probably not going to do him any good. If he's able to get damages, then that might be worth more than what the contract was worth, depending on how the court will calculate the damages. Now, this is a 1972 case, and the judge talks about the Misrepresentation Act of 1967. So after this act of Parliament, both representations and warranties are treated the same. So the judge explains, it doesn't matter if it is a representation or a warranty, so I'm not going to get into it. Like I said, they're very similar, so the judge isn't going to bother to decide which it is because it doesn't matter. The remedy, the outcome, is the same for either. If you're enjoying today's episode, please subscribe, give us 5 stars and a review. It would really help me out. Also consider going to the website, 4, as in the number 4, Legal English, no spaces or dashes.com. That's 4legalenglish.com. You can check out our blog articles, available courses, and the show notes for this episode. If you have any questions about the Jarvis case, please comment. It's a great way to practice and improve your legal English skills. Right now, we're about to open up enrollment for our first legal writing course, Elemental Legal Writing. This course will be a little bit different than the other courses because it's going to be cohort learning. All the students will start and work through the course together and finish together. So because of that, there's limited enrollment. If you're interested in that course, if you're interested in improving your legal writing, then please check it out. Go to 4legalenglish.com/writing. If you sign up soon, then you might be eligible to get an invitation to enroll in the course before the enrollment officially opens. Please take advantage of that opportunity. There are limited seats to this course. It's going to be a small cohort. And because it's going to be the first cohort, the first group of students going through this course, it is going to be offered at a substantial discount. So don't miss your chance. This is a great way to improve your legal writing. The legal issue. So how to calculate the damages? The court agrees that there should be damages in this case, but how do we calculate them? Let's first look how the trial court did it. Basically, the trial court reasoned that Jarvis got, quote, half the vacation he paid for, unquote, so he got half of the price of the vacation back. So he got this full vacation, but he only had to pay half price for it as a result of the trial court's decision. Keep in mind that Jarvis won in the trial court. The plaintiff won. He was awarded damages, but he also appealed. So it's usually pretty rare for the winner to appeal, but certainly it does happen, and this is one example. He was awarded damages, but he thinks that he ought to have been awarded more damages. And Lord Denning looks at some precedent, some prior precedent, including Hamlin versus GWR, which said that damages cannot be given for the disappointment of mind occurring by the breach of contract, and some other cases that were kind of similar. So in other words, just because you were disappointed or frustrated by the contract or how the contract was not lived up to, you can't get damages for that. Mental pain or duress, that's not under contract. Under tort, it might work, but not under contract. And then the court goes on to expressly set new precedent. Lord Denning even says, quote, I think that those limitations are out of date, unquote. So now the court is ruling that in a case for damages in a breach of contract, the plaintiff can recover for mental distress, just like you can in tort. Now, traditionally in common law, tort and contract law were very distinct. At one point, you'd even have to go to a different court. And for a long time, you'd have to choose, is this a tort claim or a breach of contract claim? You couldn't claim both in the same lawsuit. Now, over time, a lot of those distinctions have kind of been blurred or have gone away completely. This is another of those distinctions that is kind of disappearing. One of the advantages of using case law as precedent, as creating law or explaining the law, is the court can kind of give some examples. In this case, the judge does give some examples, or rather he discusses what another judge, Lord Justice Davies, gave as an example. If somebody buys a ticket for transportation from their town to another town, they form a contract. If the ride doesn't show up, of course they can get damages, for the cost of the ticket. But what about other damages? Maybe that is his only day off. That was the only time that this person could travel at this location. They were looking forward to it. Maybe they had other errands or things that they had to do when they arrived there, or maybe it was just to relax. And so the court held that someone is entitled to general damages for the disappointment or for the loss of enjoyment that they should have received under the contract but did not. It's also interesting to point out that one of the other cases that the judge cites is also Swan Tours. He talks about Stedman versus Swan Tours. I'm not sure if Swan Tours is still in business, but I'm not sure I'd want to book my vacation with a company that often seems to end up in legal disputes that make it to the appellate court. So the final ruling of the court was that the appellant gets about twice as much money as he paid for the vacation, £125. So the appellant wins, Jarvis wins the appeal. So what do you think? Was this a just decision by the court? In a breach of contract case, should the plaintiff be allowed to recover damages for mental disappointment? What do you think? If you want to learn more about this case, go to the show notes and you can download a PDF, a short version of the case, and also give a link for the unabridged version, the full version, available online. This is one of the cases that we use in Elemental Legal English, our flagship legal English course. We talk about it in that course in a little bit more detail. By reading some of these landmark cases, it's a great way to improve your understanding of the law and the common law in general, but also your legal English skills. One of the interesting things about reading cases is there's always different terms, different concepts that come up in different cases. So even as a lawyer, you might have to learn different terms that you're not normally used to. But certainly there's lots of legal English terms. Some of the legal English terms that we've discussed in the podcast today are learned judge or learned colleague, representations, misrepresentations, warranties, guarantees, damages, precedent. Are there any other terms that I discussed in this episode that you weren't familiar with? If so, drop a message in the comments. What questions do you have about Jarvis versus Swan Tours? Was this an interesting case? If you enjoyed the podcast, please subscribe, give us 5 stars, and a review. Go to the website, forlegalenglish.com. You can check out our blog articles, available courses, and the show notes for this episode. If you're interested in the new legal writing course that's opening up, go to forlegalenglish.com/writing, and you'll get more information there. The For Legal English podcast is adjourned. Don't miss the next docket call.